We're delighted to have such a full house here, many familiar faces, some not so familiar, bless you. I'm Mike Schaeffler, and I'm going to introduce my friend next to me here, Michael Beforth. Mike is an associate in our litigation group. He had the misfortune of articling at another big Bay Street firm, but came to his senses and joined us, thankfully, in 2010. He got married on my 50th birthday a year and a half ago. He's married to Stephanie. They have a dog called Brannigan, which is an interesting creature. And he and I have done quite a lot of work together, and we've done some risk work. I showed him what these charts look like a little while ago, and he got interested in that, and so now here he is today, and hopefully once we get through the introductions, we'll talk a little bit about who knows what, who has what kind of experiences, and together we'll then work through this situation. And what we're going to do is build a couple of charts so that you get a sense as to what's involved. So, Mike, over to you for a moment.
Hi, everybody. This is Michael Schaeffler. He was kind enough to actually attend my wedding on his 50th, so good on him. He's the co-lead of our Canadian Litigation and Dispute Resolution Group. He's also a global practice leader in litigation and dispute resolution across all of our platforms. He's got a lot of experience in both litigation and arbitration, both domestic and international. And I've worked on a couple of international arbitrations with Mike, and this method of risk analysis, which we're going to talk about today, has become, at least in our experience, increasingly popular in that sphere. So it's interesting, and I hope you're able to enjoy it today.
So I have a question. Who has, there's a huge background which is distracting. Can you hear me okay? Okay. And I was also supposed to remind all our friends who've joined us on the webinar, I'm told there's thousands of people that signed up on the webinar as well, that you're going to get your accreditation automatically, whereas the people in the room had to sign the sheet that's in front of me. So don't forget to do that. So I have the first question about your backgrounds. Who has never heard of risk analysis, working with decision trees and allocating probabilities to come out with a predictive value of what litigation might be worth? Don't be shy. Okay, at least one. Two, perhaps. The rest of you have all done decision trees, and you're just here to get your accreditation, correct? Roger, Pete, you included? Yes. Who in this room is a Wolverhampton Wanderers football fan? Roger, Pete. Who is a Manchester United fan? That's really unfortunate. Who supports Liverpool? Oh, Manny, I see your hand went up. So that's good. So what is risk management? Risk analysis in litigation. Mike, I don't know what the next slide. Perhaps we might talk about that just for a moment. This is what we want to do this morning. We're going to talk, obviously, about what it is, how you do it, and then there's a few ins and outs that I think you need to be aware of. And I think, let me just begin by saying the biggest approach, the biggest point to keep in mind in the approach to all of this is that you're not going to take a bunch of numbers, punch them into some chart that you're going to build, get a number at the end that says $14.2 million, and that's what the trial judge is going to find. That's not what this is about, and it's critically important that one understands that. This is an aid. This is something to help folks that deal with risk management, external counsel, people that deal in-house. There may be organizations, in fact, Mike and I are aware of some organizations that require that these analyses be done for every case before green light is given for it to proceed to trial. So these are the types of things that you need to keep in mind throughout. It's not a formulaic response to some litigation. If it was that easy, we wouldn't have trials, we wouldn't have arbitrations, because we would just all agree to punch this stuff into the formula and people would start writing checks. So you have to keep that in mind. There's a couple of other things that we'll touch on, but if you look at this list here, the fourth bullet from the bottom, you'll see a note about privilege. So this has come up more in the U.S. context. I've been down with some colleagues in the U.S. to talk to insurance-based clients who are very much at the forefront of this. And there's always a concern about preparing this information in a way that it may not be privileged. So if you don't have an in-house lawyer or an external lawyer who's involved in this, you may have to produce this. So you need to be very careful about ensuring that the usual steps are taken to ensure that whatever it is you're working on is covered by either solicitor-client privilege or litigation privilege. And obviously involving a litigation lawyer or some lawyer is a good thing to do, and making sure that you mark these charts, privileged and confidential, prepared for litigation or in contemplation of litigation. Those are sort of the usual things that you need to be careful about. I think that's enough on the introduction. Mike, maybe you can give us sort of your take on the introduction to what risk analysis is in litigation.
Sure. Fundamentally, I think this method of risk analysis is a way to bring some structure and measurability to what is inherently an uncertain process of assessing risk in litigation. There are a lot of uncertainties and factors that go into determining what your likelihood of success is, and this is a way to quantify it, at least to a certain extent, to help you in assessing your client's exposure. So, as the slide says, it's a useful means of organizing uncertainties. You could have 1, you could have 10, you could have 20. We're going to show you an example later that we worked on in real life, which had a number of different outcomes that had to be assessed. And regardless of how many you're dealing with, it's a method that allows you and hopefully your clients to feel more comfortable in assessing their exposure. So we've all dealt with the typical risk assessment language. You know, there's a good chance of this. In all likelihood, your outcome will be X, Y, Z. You've got a strong case, you've got a not so strong case, but nobody's really sure what that means when you break it down. And as Mike said, this isn't a way to arrive at a number that's going to be your outcome at trial, but it is a way to quantify what your exposure is going to be systematically. You can identify your risks, your uncertainties, and break them out into something that's measurable and that you can play with in a systematic sense. It also allows us as counsel to think about the issues in a rigorous and systematic manner. Sometimes when we give a gut feeling analysis, your assessment of the issues is at a higher level than it might otherwise be if you look at things more systematically. And this method forces you to look at things in a step-by-step way and look at each issue and assess the uncertainties associated with that.
I just want to interject something. When you're dealing with a new case, a new file, and you're trying to figure out what your exposure is, and let's just say you call up, you're all in-house, and you call up external counsel, and you talk about the case a little bit, and you want to get sort of their initial assessment. And maybe you might even ask the lawyer at the early stages, you know, based on the discussion and based on the material so far, you know, what do you think? And the lawyer says, oh, I think you have a pretty good case. So you say, okay, well, thank you, let's proceed, and you hang up and you go to your next meeting, and the lawyer walks down the hallway and talks to her partner and says, oh, I just got a new file in, you know, a pretty good case, at least a 50-50 case. I think we got a pretty good chance. You walk down to your colleague down the hallway and you say, I just talked to our external counsel. They think we have an 80% chance of winning. Good case, good arguable case. So part of what you're trying to do with this is put a little bit more meat to this so that you're taking some of those subjective elements that come in and some of the subjective language that often clutters and confuses what the actual legal and factual issues may be. So as we walk through this today, remember that conversation because we're not saying it's a science. Nobody says it's a science. But rather than having a good arguable case that's either a 50% case or an 80% case, we're trying to be a little bit more precise. That's sort of the gist of this.
And the last point, which is relevant to what Mike just said, is you really need to be careful about the assumptions that go into this, and you need to be rigorous. You know, garbage in, garbage out, as it says there on the slide. If you're not careful and objective in your assessments of the issues, your result is not going to be as useful as it might otherwise be.
So the question then becomes, do we use this in every case? Should we use it in every case? Is every case suitable for this? And my answer is that actually it doesn't really matter how big or small the case is, because you might have a small case. I'm sure you've all run into even small claims court cases where the precedential value of a particular outcome is such that you've got your full attention on this pesky little file, and you want to make sure that it's managed in the right way so that the other 50 cases that are waiting in the wings aren't negatively influenced by that particular case. Does that mean that in each case you're going to go and build one of these charts and spend the time and the resources to understand? You probably don't have to do that, because often you can just do that in a memorandum format, and folks can, you know, give a pretty good assessment in simple cases. But I would suggest when you have significant reputational risk, when you have significant bucks in issue, when you have the potential for adverse impacts on other matters that might be out there, you probably should be doing this. And as I said earlier, in the financial institution context, we know at least one who requires this analysis in order to allow a case to go to trial. They use it for other purposes as well, as I'm going to demonstrate. But one of the things you can do is an early case assessment as well. And that's not a bad thing to do sometimes, because we all know how long litigation can go on in this day and age. Sometimes you build your risk analysis on the bare bones that I just gave you in that little hypothetical. You've had a discussion, you've gathered some initial documents, but you haven't had a chance to examine witnesses under oath. You haven't collected the other side's information. You don't know what they have to say about the case. So you start off with a particular picture. And it reminds me actually of an anecdote, or a true story, but something that's become a bit of a legend here in the firm. Paul Lamech was one of our litigators very early on. He became a judge. And he had a little rule, a little practice, where at the beginning of each file, he would, in his handwriting, he would take a note and he would stick it on the inside of the file folder. And he would then relay his impressions, his first impressions of the case. And time would go by, and the matter would then get ready for trial. And as he was preparing for trial, he would go back to that little note in every case to check for two things, really. Was his gut still in the right place in terms of, are we still doing what I think was the initial response to the set of facts? And the reason he did that, of course, is because in his world at least, he thought that the trial judge would most likely have that initial same impression that Paul had. And if those were still aligned, then he figured they were probably on the right track. The corollary to that was, if suddenly the theory that was being presented in opening statement was different from what was on that sheet that he'd written earlier, he wanted to know why that was. And sometimes the reason for that was because the case that we were prosecuting or defending, as it went through discoveries and production, et cetera, turned out to be a bad case. And people were coming up with new theories and new arguments to justify something that in the end didn't really mesh with the realities of the situation. So you can do an early assessment here, build your chart, you know what the legal issues are early on. There might be new legal issues that emerge as you go through the case, and you revisit your risk analysis and see whether it changes. You're going to get damages quantification in most cases as you proceed. And you can work that into the analysis every once in a while at major steps in the litigation. It says in here, of course, strategy decisions. That goes without saying. But at the bottom, you'll see settlement discussions. And you're going to see when we go through this model, our little first hypothetical at least, we've got this set up so that it begins with a paradigm. You have a lawsuit, and you have an offer that's been tabled. And the question becomes, is that offer reasonable in the circumstances? But before we go there, though, there's a different way to look at this as well. People might agree or disagree with this approach, but one of the things that I always found when you go into mediation is sometimes there's a reluctance to put your number out on the table first because, quote, it's a sign of weakness. I don't agree with that. Sometimes, and there are studies on this, when you put a number out first, you are setting the anchor point, the focus point. So if the fight is between $20 and $100 million, let's say, and you're first out and you say, okay, you're the defendant, you're going to say, look, I've looked at this. We know internally we're on the hook for something here. Why don't we start the bidding, and we're going to put 25 on the table. Now, sometimes what's going to happen is the response is going to be nothing. You know, you're probably not going to settle that case today anyways. But it may be that the other side has done their own analysis in this, and they know that they've got some exposure as well. So now they've got 25 million on the table, and that might be something that's worth talking about. They might not settle for 25. Their number might be 50. But what you've done is you've narrowed that window now from 25 to 50 as opposed to 20 to 100. And one tool that's quite useful here, I think, is the use of these charts. And you can use these with the mediator. You can give this to the mediator and say, you see this only. You might choose to give it to the other side. You may not want to do it, but there may be reasons in some cases where you want to do that, depending on the nature of the case. So there's a lot of creativity in the use of this tool that can come into play. And you know, every case obviously is going to turn on its own facts, the people that are involved, et cetera. But I just want I want to leave that thought with you as to how many different uses you want to put to this particular tool. Mike.
So let's talk about our hypothetical then. So you're an employer, or your client is an employer, and they come to you with a wrongful dismissal claim that's been brought by one of their former executives. He or she was paid $1 million in salary a year, and each year was also entitled to $1 million in stock options. And our defense to the wrongful dismissal claim is that there's a mandatory retirement policy that applies across the board, and that was the reason for this executive's retirement, and there's no notice that needs to be given, no damages. The executive, in response, has raised a number of defenses. The first is he or she didn't know about the policy and therefore couldn't have agreed to it. Alternatively, if he did know about it, he says, okay, this policy didn't apply to me. I'm an executive. This was a policy that applied to regular employees. And finally, he's raised the argument that in any event, policies like this are unconstitutional and unlawful. He says he's entitled to 2 years' notice, so 24 months in salary and 2 years of stock options. We, of course, say, well, you're not entitled to anything, but if you are, 12 months at most.
Our clients are always right.
Of course. But sometimes triers of fact don't see it that way. So
they're always wrong.
This is helpful. So the claims for 24 months notice, 2 years salary, 2 years stock options for a total of $4 million. And this executive has approached you with an offer to settle for $1.5 million, and your client wants to know, well, is this a reasonable offer?
So you can have that conversation again that we had earlier, in a slightly different context, and say, yeah, you got a good case, all the things that you see there on the slide, strong case, almost a sure thing. What does that mean, almost a sure thing? 51%? 99? I don't know. Some possibility. What does that mean? 1%? 33%? So I'm sure you've all had conversations with counsel over the years where some variations, if not those words, have been used to tell you about the chances of success or failure in your case. And I would suggest if you've had that kind of language put to you without much more substance, you've usually left the meeting or hung up the phone thinking, geez, I don't really know what that means in this case. So there is this different way, Mike, if you put this next slide up, there's a different way to look at this. And let's talk about the concept first, just for a minute, so that you sort of get the gist, the hang of what it is that you need to do in each case in order to build a chart that not only pumps out some numbers at the end, but a chart that actually takes into account properly the various decisions that need to be taken in each legal analysis that applies to a case. And the trick to this is, in all of these circumstances, the trick to this is always to have a decision point. You have to go through the legal analysis, and we'll show you how to do this in some detail, but the trick is to arrive at a situation where you have to ask yourself, is the outcome going to be this or this? And the this or this, when you add those two together, always have to equal 100%. Because those are the only two options that you've identified for that particular decision. So it's 70-30, 80-20, 50-50, whatever. They always have to add up to 100. In more complicated analyses, there might be 3 or 4 or 8 different potential outcomes to that particular issue. And that means that for those 8 outcomes in the most complicated of analyses, they again have to add up to 100. So as you go through this, when you're doing the math at the end of the day, you always have to do a check at the beginning to make sure that the percentages, the likelihoods that you've allocated add up to 100. And at the end, we'll show you on the column, you come up with a column typically that gives you all of the numeric outcomes. Those too have to add up to 100. If they don't, there's something wrong in your model. And if we just look at this chart here for a moment, so you've got decision number 1. Okay, 1 is whatever the decision that needs to be taken. A duty of care was owed, yes or no, just to keep it really simple. So yes, A, no, B. And then you have A, let's say it was a prima facie duty of care. C then is whether it's negatived. There are 2 potential outcomes here, outcome 1, 2, 3 for decision A. Those might be whether there are policy considerations that negative the duty, something, and anything that might negative the duty or impact that analysis. So you have to build that tree in order to match the legal issues that you have identified. And each time when you work through that, you have outcomes that you always have to add up to 100% across the board. So, Mike, why don't we start building the tree? Does anybody have any questions about the facts that because we're going to spend some time on this employment situation? Is that all clear to you? Okay, why don't we start that, Mike?
Sure. So The process of building this risk analysis tree has 5 steps. So the first and probably the most important is you need to identify what the ultimate issues are that you're going to be dealing with, and to the extent you're able to, at whatever stage of litigation you're at, identify any influencing factors that are going to be in play, whether those are evidentiary challenges you're going to face, whether you've been through discoveries and you know that your witness or the witness on the other side is going to have credibility issues, or alternatively is going to be very likable. Those are things that will go into your analysis of the probabilities of each of these issues. So once you've identified those issues, you then need to define your outcomes, which Mike talked about a moment ago. And it may be as simple as a yes or no question. It might be a question of 5 different outcomes arising out of one issue, and issues may have sub-issues, which we'll see here in a moment. Once you've defined your outcomes, you then look at those outcomes and you assign them probabilities based on your legal analysis, the evidentiary factors you know about, whatever information you have to enable you to make a decision as to probability. You do your math, which I'm not great at, that's why I went into law, but thankfully it's pretty simple. And then you interpret and you refine your results both at the time and as you go along. So the 2 issues that you're always going to be faced with are liability and damages. And these can be dealt with together in one analysis or in 2 separate analyses, which is the way we've structured this example today. So we're going to do a liability chart and then a damages chart. So in terms of the liability issue, or the liability problem, the issues you're going to need to deal with are, first, did the plaintiff know of and agree to this mandatory retirement policy? Depending on the answer to that question, you're going to have to assess whether this policy applied to executives, and you're going to have to deal with the question of whether the policy is lawful. So those are your 3 issues on the liability side that you're going to have to address. On the damages side, it's pretty simple. If liability is determined, is the proper notice period a year or 2 years? And in each case, are stock options part of what's owed to this executive?
And if I can just say one thing, the reason that I always like to divide the analysis into liability and damages so that I always have 2 charts. I have 2 sets of charts. Some people want to put it all in one chart because, you know, we live in this email age where everything has to be really abbreviated and you know, have to get it in 5 minutes. But I actually think in this area it makes a lot of sense to do the legal analysis first. And don't worry about the numbers for the time being, because the numbers often are just a consequence of your legal analysis. So in this particular scenario, you'll see how that works out. If you work on your liability analysis separately, you can adjust it as well. What's going to happen is once you've concluded your liability analysis, you're going to come up with a percentage likelihood of wins versus losses. And that's what's going to drive your damages analysis, as you're going to see now, Mike. Okay, actually, that's a good point. Let's just pause for a moment. When you're doing these, and I've alluded to this, this is not science. Okay, I can't stress that enough. It is not science. And the reason it's not science is because there are a lot of variables that go into this. So take a look at the things that are up on the chart for a moment. There may be evidence that's great, except there's a problem. It's not admissible. So you need to deal with that in your analysis. There may be an issue, there may be a risk analysis as to whether the evidence gets in or not. You may have some issue there. Witnesses. We're all human beings. We have good days, we have bad days, we have general tendencies. Some people love the attention. They are going to be superstars no matter what. Some people don't. They're the best people you ever knew, but you put them in a witness stand, they're going to suck. And so if your case hinges upon that particular person's evidence, you may want to factor that in. We'll talk a bit about how you do that in a minute. Interlocutory determinations, again, there may be some issues that affect your initial analysis. There may be some legal issues. The law might change along the way. The rule on summary judgment motions might change along the way. Who will be the judge? You know, if you go to the commercial list and you get a commercial list judge on your matter who's been doing commercial cases for 15, 20 years, awesome. The next day you go on the same case and you appear in front of the newly appointed commercial list judge who practiced family law for 35 years. You're going to have a bit of an issue. They're really good at family law, mind you, but they may not be so good at this particular case. And then at the end, you'll see appeals as well, of course. This can repeat itself. And where we've been retained to do work, by the way, is on appeals where one firm has acted and there's been a particular outcome, and now the client wants to take a fresh look at this, and you work with the other law firm on either appealing or responding to the appeal, and often it gets elevated because there are other issues that get engaged, and the executives want to see this kind of stuff. So you can work on the appeals as well. Not so much relevant here, but in the U.S. where you have treble damages in a lot of these cases, at least in the commercial context, these numbers get pretty big. So you get all kinds of different charts with different probabilities that ultimately are used to make C-suite type decisions. So that's where this all comes into play.
So once we've identified our issues, the next step is to define your outcomes. And in this case, it's a simple case. All of the outcomes are binary. So on the liability piece, the outcome of the first issue will be either the plaintiff knew about and agreed to this policy, or she didn't. And if that's the case, you then go to your next issue and you define the outcomes there. This policy either applied to all employees or it applied to employees only and not executive level employees. And depending on the outcome to that issue, you then go to your third issue, and the outcomes are this policy is either lawful or it's not. And this will become fairly clear in the chart in a moment, how you go through these. On the damages issue, again, your outcomes are binary. You've either got a year of notice or 2 years of notice, and in each case, you're going to either have to add in stock options or not.
So this is what happens in every case. There's a blank piece of paper. Mike knows this, or we do it on a flip chart. You really get your imagination going on these things, and you have a discussion about what are the legal issues. So right now, what we've got is a situation where we need to take a decision. We need to help our client with a decision. Do we settle or do we litigate? And we know that if we settle, it's $1.5 million. That's the easy part. What happens if we litigate? So let's build our little decision tree now based on the legal analysis that we've done. So, one, we know that if the plaintiff knew and agreed, then that's the end of it. The way we've done our legal analysis, if the policy applied to this plaintiff and she agreed to the policy, we say the legal analysis suggests that that is a complete defense to the claim. So that means the employer in this case would be successful. Now, what if the plaintiff didn't know? Is that the end of the analysis? It's not. You have to now further divide the issues into, did the policy in fact apply to her? Or, you're going to see, if the policy did in fact apply to her, we're going to, did not apply to her, the employer is going to lose. If the policy applied to everybody on their face, that's not the end of it again. It may or may not result in success. Because if the policy is lawful, well, we're good. But if it turns out that the policy is unconstitutional or has some other defect, we're not going to win. So what you now have is a very basic framework for analyzing potential outcomes. This is obviously oversimplified in order just to give you sort of a sense as to how you would go about building a chart like this. So what do you do with this then?
So once you've got your chart and you've set out your issues and your outcomes, you need to assess and assign probabilities to each outcome. I wish I could just pop this up. I can't, so I'll go through the first couple of steps. So if you litigate, your first question is, did the plaintiff know about this policy? And based on what you know about the evidence at this point, you think it's pretty likely that this plaintiff probably didn't know about the policy.
Can I just interrupt? Can you all see the numbers in the box? It's a little so the box that says plaintiff agreed and knew and agreed mandatory retirement policy applied. There's a 0.2 that's been inserted into that box, and that's because on the analysis that's been undertaken currently on all of the information that's available, the conclusion is there's a 20% chance that that policy applies. And you can debate, and you can always debate, and I'll tell you that right now. Could it be 30%? Could it be 10%? Could it be 40%? We'll come back to that in a little minute. But for the purposes of this exercise, I just want you to consider right now that we've said there's a 20% chance. That must mean by default that there's a corresponding 80% chance that the plaintiff did not know. Remember I said these two always add up to 100? So here's your first example of how that works. So Mike, as you go through, just highlight the numbers so for the folks so they can follow along, please.
So we think I mean, I don't tend to go above 80-20, so this is a fairly certain deal that it's probably going to be found that the plaintiff didn't know about the policy. So the next issue we look at is whether it applied to executives. And the numbers we've assigned here, in case you can't see them, are a 60% chance that the policy did not apply to executives and a 40% chance that it applied to everyone. So based on what we know about the case right now, any influencing factors that we've identified, evidentiary challenges, witness issues, it's not as certain this issue is the first, but it's more likely than not that this policy did not apply to executives. So there's a 60% chance here that our client loses on this issue. If you go to the 40% chance that the policy applied to everyone on its face, you then look at the lawful, unlawful issue. And again, based on what we know about the law, currently we've assessed this 60-40 that the policy will be lawful versus unlawful. So more likely than not, but not as obvious an issue to us as the first issue of whether the plaintiff knew about the policy or not.
And, you know, just to go back to this, the first decision there about the plaintiff's knowledge, you can imagine in a case such as this, that is a key issue. And whether the plaintiff knew or not is going to, that finding that is made at the end of the day by the trial judge or the tribunal or wherever this is being decided, if it goes, is going to depend on that person's credibility, on our witnesses' credibility, how good were our HR people at documenting policies that were promulgated from time to time, how good were they at documenting meetings that took place, if any, with this person, how good a witnesses will these people all make? And so when you get into this a little bit more and you realize, you know, you take into account these softer issues, but real life issues that need to come into this somehow, you've got to look at your 20% and say the plaintiff knew and agreed. So what I'm saying here is that there's a very small chance really that this outcome is going to happen. Because as Mike said, 80-20 in litigation. If you just step back for a moment and think about your various litigation files over the years, or anything really in life, 80-20, that is pretty close to a guarantee. There's some room, but you know, when you contrast that with 60-40 in some of the other questions, what you're really saying there is, based on your legal analysis, it's probably more likely than not that That's more a 60-40. 70-30 probably would mean this is a pretty strong case, and here's why. 80-20 is not necessarily a slam dunk, because it is litigation, but it's fairly close. When we get into the more recent thing that we actually did with a client, you'll see the various permutations and what effect that had also on settlement dynamics.
And just before we move on, the next slide will make this clear, but as Mike said earlier, each of these outcomes, when you're assigning probabilities, have to add up to 100. So you're looking at each one separately. You're assessing based on what you know about that issue, what the probability is of these various outcomes coming to pass. If you somehow miss a step and you don't get to your 100% on each outcome, you're going to have an issue at the end, and Mike will show you why now.
So this is where you get into statistics. Does anybody know statistics? People familiar with how I had to learn this too. It's not that hard actually, but conceptually you have to apply this the correct way each time. Okay. So so you'll see on the right hand side, the red boxes have now been allocated with outcomes. Percentage outcomes in terms of the employer winning and the employer losing. And you'll see that there are, 20, there's about a 40% chance in this case of the employer winning. And we do that, we've taken the box that says employer wins, 20%, and we're adding the 19.2% in the other box where the employer is successful. Those are 39.2%. So for our discussion this morning, that's 40%. The others, if we've done this all correctly, have to add up to be precise, I guess, 61.8%. So if you take your 48 and your 12.8, I think that 60.8, we're close. So those add up to 100%. How did we get there? You multiply the probabilities through on each row. So on the first example where the plaintiff knew and agreed, as we've said, that's the end of it. That's 20%. You put 20% in the box at the right-hand side, and you see the line that extends from that box visually just to make it easier to understand. That translates into a 20% win scenario on that particular issue. Now drop down to the plaintiff didn't know tree. So this whole tree now you know why it's called a decision tree. It has a bunch of different branches attached to it. So the plaintiff didn't know, what is that? 80%, so 0.8. And then the box to the right and up one, policy in fact did not apply, 0.6. So what you do is you multiply the 0.8 into the 0.6, and that gives you 48, 0.48, 48%. So that 48 number goes in that box, and that is an unfavorable outcome, so the employer loses 48%. Everybody got that? Okay, and then you multiply that through on the bottom as well. It's the same thing. So you take your 0.8, plaintiff did not know, multiply it by 0.4, policy applies to everyone on its face, and then multiply it by 0.6 and by 0.4 respectively. And those numbers will give you 0.192, 19.2%, and 0.128, 12.8%. And you can appreciate, just as you're looking at this, when a number changes. So this 0.8 number, plaintiff did not know, is a big number. And it drives this analysis through. So when you're changing that big number a little bit, let's say it goes to 0.7, it's going to have a fairly material impact on this analysis. So you keep that in mind. And I think the critics of this, with some justification, will point to that. And one of my partners is always on me about this. If you want to justify another outcome, you just change that from 0.8 to 0.6. Yeah, he's right. But if you can justify that 0.6, good. Let's understand why one person wants to say 0.6 and the other person wants to say 0.8. So rather than having that, you have a good case discussion, in this situation, when you have that debate over numbers, you get to put a little meat on the bones because you get to understand, why does he think it's 60% and why does she think it's 80%? So I think it's a good discussion tool. Mike, what's next?
So now we've got our liability outcomes, and based on the 4 outcomes we see, our client has a 40% chance of winning and a 60% chance of losing based on what we know now. So now we need to look at the damages piece. And I'll go through this relatively quickly. It's the same issue. You identify, the same process. You identify your issues, your outcomes, and then you assign probabilities. So your outcomes are your client wins or your client loses. In the case of your client winning, of course, you pay nothing, so the analysis is done. If your client loses, well, then we have to look at the damages issues I spoke about earlier. Is your client, and this is a little backwards, but the first issue is, well, what's the proper notice period? Is the executive entitled to 1 year's notice or 2 years' notice? And out of each of those outcomes, you then need to determine, well, do stock options apply as well? So you have 3 sets of outcomes, winning or losing, notice period, and then in each case, stock options applying or not, and you come out to 4 potential damages outcomes of $1 million, $2 million, $2 million, or worst case scenario, $4 million.
And just, is that clear? Does anybody have any questions about this? Okay, so now you assign your probabilities just like you did with liability, Mike.
So we already know from the previous liability analysis we did that there's a 40% chance that our client wins and pays nothing. In the 60% chance that our client is unsuccessful, well, we now need to do the same thing we just did, which is apply probabilities to the various damages outcomes we're looking at. So we think, first of all, that there is a 40% chance that the proper notice period is a year. So less likely than the 2-year period, but it's not as clear as the 80-20 analysis we did about whether this executive knew about this retirement policy. And in each case, and this is the same for the next option, we've decided that there's not enough evidence right now for us to make a determination one way or another as to whether stock options will be part of what this executive is due. So we've called it 50-50. So when you break everything out here, you've got a 40% chance that in the event your client is found liable at trial, the proper notice period will be 1 year, and a 60% chance that it will be 2 years. And then the issue of stock options right now is up in the air, so to speak.
And just pausing there for a moment, if you just look at this particular decision tree now, at least in an employment case like this, that is, in fact, the analysis that a trial judge or a tribunal is going to go through. They're going to decide first, what is their liability on the part of the employer. They'll go through their analysis, and it's going to be yay or nay. And then when they get into the damages analysis, they're going to figure out, well, what was the notice period? And the way that these charts work in reality, the beauty of this is often these cases aren't, 1 year versus 2 years, A versus B, or, blue versus black. There might be shades of gray in between there, and you can do that. So you might say, well, we think at a minimum, if we're going down for a year's notice. And we know that our worst case scenario is 2 years. But it's possible, based on our research, that the judge might give something in between. So if you want to try and be even more precise in this analysis, because all you're doing is assigning a statistical value to this case, you might put in 16 months, and you might also put in 20 months. And you then would have, so now you would have 4 boxes there. So 1 year, 16 months, 20 months, and 24 months. And you would go through the same analysis. You would ascribe the percentage likelihood to those. Now those 4 boxes have to come out to 100%. Okay? And you can say, One of them's only got a 10% chance because I don't think we're going down for 2 years, if you feel confident about that, because of there's some precedent out there that tells you that, you know, the weight of authority is in the 15, 16-month range. Well, that means your 16-month box is going to be fairly high, you know, 70, 80% perhaps, and the others will be correspondingly lower. But as long as they add up to 100%, when you then add on the stock options, no stock options for each of those 4 boxes, so this thing gets a little bit more complicated. That's the way you would play with this kind of a chart in order to take into account more options than just the ones that you've initially identified. So you work through the math. Mike said you're not good with numbers, so you multiply those through just like you did earlier on liability to get to those 4 boxes we had earlier. Now what you're doing is you're multiplying through the 80%, 60% times 40 times 50 is 12%. And so that line, that branch in the decision tree, which gets you to $1 million, there's a 12% chance of that happening according to this analysis. When you do the same multiplication for that branch, but at the end stock options are included as well, so that's the $2 million. Because we've assigned 50-50 at the end, that 2 will be 12%, but this time it's 12% of 2 million. And then on the bottom, this is now the 2-year notice. Again, you multiply it through same options or not, and that comes to 18%. Okay, so that you now have 40% likelihood of $0, because that's obviously where the employer wins, plus 12%, plus 12, plus 18, plus 18 is 100%. So this has been done, thankfully, correctly. What does that mean now? What do you take with that? So Mike, if we go to the next chart, what that is telling us, and I apologize if you can't all read this, the bar graph just simply puts it's more into visual context what I've just said. The 40% likelihood of $0, the 12% of $1 million. We've added the 2 together. If you go back, there's a 30% chance of $2 million having to be paid out. If you look at that, you add those together, and there's a 20% chance, I think. 12% chance for $1 million and 18% chance for $4 million. At the bottom of this graph, you can see how you just tie all this together. Okay, so you multiply the percentage with the corresponding dollar figure, and you add them all up. And if you go through the math here, obviously 0 times 40% is 0. $1 million times 12% is going to be 120,000. 2 million times 12% is 240. 2 million times 18 is 360, and 4 million times 18% is what, 720. So when you add those all up, you get $1.44 million. That is not what the trial judge is going to find. That is simply an expression of what the facts and the legal issues that you've identified, given your assessment of the case, suggest is statistically the most likely outcome. Sort of like a computer crunching all of this. Is a trial judge going to find that? Maybe. You don't know that for sure. But what you do know is that a correct legal and factual analysis drives you in this general direction of just under $1.5 million. So there's a little bit more now that goes into this, because now you get into, what do you do with that information? So the employer has done the analysis and has said, well, all things being equal, I'm writing a check for just under $1.5 million if I go to trial. But I haven't factored in yet the fact that there's a legal cost that's going to be involved. We don't know if there's any Rule 49 offers out there, for example, which is going to drive this, by the way, as well. This is really valuable for Rule 49 offers, I would suggest. So here we've got, this is very cheap, $140,000 or $160,000 to take this case to trial. And then the parties' cost, try to put some kind of the management cost into this and figure out, what are we spending on this that's distracting us from the rest of our business. And then there's the risk premium. I don't know if you can see that, but so the first expansion of this number, this 1.4 million number, either way, I'll tell you in a minute why, is legal costs. And then below that, there's a further expansion of that range with respect to basically opportunity cost. And then the last one is there's a premium. We all have homeowners insurance, car insurance. Chances of us using those in our lifetimes are slim to none, but we pay those thousands of dollars every year for the protection that those insurance policies are supposed to give us. And the same thing obtains with respect to litigation. There's a premium to be paid to settle a case to avoid a potential $4 million sledgehammer. And that's what that tries to capture there. So what you then see is if you're the plaintiff, just look at the left side of this for a moment. If you're the plaintiff and you're doing the same analysis and you go to trial, you're going to have your own costs, and you may or may not recover those costs. So from a plaintiff's perspective, you might be willing to settle for as little as 1.1 million if you've done this analysis like the defendant has. And the defendant, the employer, might want to go as high as 1.8 on this particular little example because the employer has factored in those additional costs and the desirability of paying a premium to make this go away and have certainty. So now, when you're faced with an offer of $1.5 million, you have some comfort in going to whoever you need to go to get approval or giving instructions to accept or reject that. But ultimately, that's a different decision that can be taken. So that's how this sort of works. So we've tried to give you this easy framework initially before we go on to something a little bit more complicated. Just want to pause to see if there are any questions. Yes.
When you were analyzing the liability, you had three different issues, right? Was it legal? Did they know about it? Did it apply?
Yep.
Does it matter in which order you place those issues? Because your first issue was 80-20, right? So then everything after the 80 got reduced.
Yeah, that's a really good question. And the order in which you place these decisions does matter because obviously, as I said, that number will drive the rest of the analysis. But the way we do it is you look at you have to identify the legal issues that flow. So whether or not the policy was legal or not ultimately isn't the key decision at the outset. The first thing that matters in this little example is, well, did this executive actually accept this as a matter of contract or whatever? Well, if they did, that drives the analysis. Now, you could turn around, another smart person might say, well, but wait a minute, Mike, if the policy, even if the employee accepted the policy, but it was unconstitutional, well, that might be the end of it as well. So you can certainly order these in any legal sense that makes sense. And I would suggest once you've done that and you've done your analysis, because you're multiplying numbers through, I think the numerical outcome should always be the same if the various issues are the same and you're ascribing the same probabilities to them. I don't think the sequence will ultimately matter that much. Any other questions? Okay, so Mike, a more recent actual example.
Yeah, so Mike and I had a case that we were working on for some time that was set to go to trial earlier this year. And it was set down. Oh.
Yes. Who knows how to turn the lights off?
Probably over there.
And this is, this will be also, if it's easier, do you all have the materials printed?
Yeah, but they're small little boxes.
They are small, yeah.
Well, while the dapper man in the bow tie tries to figure it out.
That's Mark Evans with a bow tie, everybody. He loves this stuff.
No, you don't want that.
How much of this analysis would you go through with the client when they're trying to make the decision? Would you just sort of deal with the conclusions with them, or do they generally like to see the analysis?
That is like one of the best questions I've heard. It depends on who the client is. In this particular case, I can tell you that we went through various iterations with the legal officer at the client, had numerous discussions with the entire team to understand and to get comfortable with what was going on here. And we're not going to bore you with all these details. This is more the fact that you see so many lines and so many yellow boxes and so many unreadable numbers is simply meant to, you know what, it's cool. It's good. Yeah.
Oh,
There we go. Is that better?
a little, maybe.
For those of you on the web, we've turned this large boardroom into a very cozy, dimly lit place. We can light candles too if that works. But the idea behind this is just to show you how complex and complicated these things can be. But to give you an idea, this was a case that turned on whether a settlement agreement was valid. And if the settlement agreement was valid, there were a whole bunch of conclusions that flowed from that. And that's all represented up there at the top. And you'll see from this, you may not see it, but I'll tell you. We assessed there was a very, very high degree likelihood that the trial judge was going to find that this settlement agreement was valid. And that's the 0.8. There's a 0.8 at the top left in the first box. And if you go over to the next row, the second box from the top also has an 80% likelihood that our client, in abiding by the terms of the settlement, had not breached any of the operative provisions. And there was then an additional issue as to whether, on top of the terms of the settlement, owing to some of the performance issues associated with the settlement, there was an additional payout, called here the APA, whether there was an additional payout required at the end of the day. And we said that there was an equally high probability that no such payout was to be made. So what you have when you multiply the 3 0.8s through, 0.8 times 0.8 times 0.8 gives you 51.2%. So leaving aside all of the other permutations, given the assessment that we had given the client, there was a higher than 50% probability that we were going to be successful on all fronts if this thing went to trial. Now, the difficulty with this case is that we weren't talking about $1.50 or $3. We were talking about hundreds of millions of dollars, and in one outcome, yes, if you can go to in one outcome, over $1 billion. And you can not see that, I'm sure, but at the very bottom, maybe Mike can point to that. Right at the very bottom, there was a 0.08% chance, a very small chance, a very small chance that might happen. But it was a chance, and it was something that was and needed to be taken into account in this analysis. Where did these numbers all come from, first of all? Dueling experts, good experts who knew what they were doing. And what was the context for this? The global financial meltdown in 2008. You can imagine the dollars that were kicking around and what experts might be able to do in a case like this, where the theory of the case is that you did something in the height of the financial markets, financial crisis, that deprived the plaintiff of using a good chunk of money to invest it in other purposes. The defense was that there had been a valid settlement agreement with respect to those issues, and that only $19 million was payable under that settlement agreement. But the plaintiffs contended that the settlement agreement had not been validly executed because there were some issues about conduct leading to the settlement agreement, and that they essentially should be put back in the same place they would have been but for all of these events. And so they hired an army of experts who did all these analyses as to what that money would have earned. And one of those analyses suggested they would have over $1 billion if our client hadn't allegedly interfered. It was complete nonsense, by the way, but that was, it wasn't so much nonsense that there wasn't actually an analysis of this nature that had to be undertaken. So all these permutations gave you a good sense as to what the statistical likelihood was of risk to the client. So at the bottom of this, of the far right-hand column, when we add up all the numbers and multiply them by all the potential percentages, you're going to see a number of approximately 66.7 million. That included, we had baked into the analysis already, the fact that 19 million would have to be paid in any event and was always open for payment. So we're talking about new money here of about 40 or 50 million dollars to understand what all the risks were. And if you just step back from this for a moment and you think about the type of case that you're dealing with here, a case that's going to go to trial unless there's a settlement, and a judge is going to be asked effectively to set aside a settlement agreement. Judges don't often like to do that. The courts actually prefer certainty. Where the evidence that was combed, this was after discoveries, after years of litigation, with the assistance of many different experts, all of these assessments were undertaken, including with our client's own internal risk team. They were totally hands-on, to answer your question. This is the best that we could come up with, and the reason that this went from 19 million to 66 is because there was a chance that the trial judge might not agree with that general wisdom. That settlement agreement might be torn up, and if that settlement agreement got torn up, there were some pretty drastic consequences. The numbers down here, if the agreement was not valid, I should pause to say one other thing. If the judge were to have found that the agreement was not valid, the judge would also have had to have made some assessment about the credibility of the warring parties. And if the judge found that the agreement was not valid, it would have been bad news for our client, because it would have driven the remainder of the analysis. Having found that the agreement was not valid, that same judge would not now suddenly decide in the decision tree along that analysis to favor our client, because I can tell you, if the judge were to have made that finding, they would not have been very happy with our client. And so that drove this analysis as well, to us concluding that if that outcome were to occur, our client would probably get slapped pretty hard with some bigger numbers, which were open to the trial judge to find on the basis of the expert evidence that had been tendered already. So I won't get into what the case settled for at the end of the day, because I don't think that would be appropriate, but what we can say to you is that this number that you see there, that 66 million, played a huge factor in the settlement. And there was a settlement at the end of the day. The trial that would have been 6, 8 months, would have been very time-consuming, very costly. This was settled for something that took into account this analysis, the legal costs that we talked about earlier, the additional premium for buying security or safety or certainty, and everybody went home happy. And this analysis, I think, was very useful, and certainly, I think, in the client's mind, was very helpful to bridging external legal counsel with in-house counsel and the C-suite, who you can imagine with the numbers that we're talking about, was quite heavily involved in making decisions about this particular litigation. So,
Peter's view?
I'm not even, so remember the partner I told you about who always dumps on me for this? Well, he's got his own now. He does Excel. I'm not an Excel person, but I know that it actually has a lot of benefits, and he's used it in his cases as well. And it's a little easier than the charts, I have to be honest, because you can manipulate the numbers almost instantly. The difficulty with the charts is, although I've got a little system developed, is you have to go through the whole thing again, which takes a little more time and can really make your head hurt sometimes. This, once you've set it up, you can just put the numbers in, you can change the variables, and if folks are familiar with Excel, you can probably see the advantages behind that. But anyway, that's just another way of doing it. If you're interested in looking at this through the Excel lens, that tool is out there as well. I don't think we'll talk much more about that. So,
No, and we won't spend
Mike?
much time on this either, because Mike's already sort of spoken about some of the hard and soft costs that can be taken into account when you're looking at probabilities. We've talked about legal costs, what you've incurred, what you might incur if you go to trial, and both what you might be liable to pay or alternatively recover based on the outcome. There are internal costs to take into account, and this was a fairly big factor in the case Mike just discussed. The internal time that was going to be taken up with respect to executive level employees being briefed and attending trial, that was a big consideration that went into the ultimate outcome. And the time value of money, depending on how long this thing is supposed to drag on, well, what's the present value of your outcomes if you're going to be dealing with this for another 2, 5, 10 years? All of these costs can have an impact, as Mike showed with those boxes on the line graph of different numbers. That can really move your exposure and the amount which you're willing to pay to make this go away, or alternatively accept to make it go away. Those all play a factor and need to be baked into the analysis you do. And it's also helpful, and Mike will talk about this a bit in the ADR context briefly, I think, because we're running out of time, performing this analysis not only from your perspective, but the other side's perspective, which can help you in coming up with an informed settlement position.
So we've talked about the advantages. I'm not going to repeat that. I think you get the idea. It's a tool. It's not the tool.
Despite the fact that we say indispensable.
Well, it is. I don't know who wrote that. It is an indispensable tool for arriving at an informed settlement position. I mean, you can take that position. I think this is. It should be clear. I'm a fan of this stuff. Others are not so much in love with it, but whatever works. And if you think that today you've seen something that might make you at least look at cases differently in the future, and with a view to maybe doing a little bit more than the old-fashioned approach, that's a good thing. If you decide that, Mike's, this is all wrong, that's fine too. No hard feelings, but I think this is something that's worth looking at. And there are actually other software programs out there like Triage, Treeage, which with a little bit of training you can work to use that. We have a couple of licenses in the firm, and we've tried it, and it's a useful tool as well. But you need to learn how to deal with it, and so I kind of like my old-fashioned Schaeffler charts. And I want to remind you, I think we've touched upon this. There are risks with this kind of risk analysis. If you put garbage in, you're going to get garbage out. And if you want a certain outcome, you can make that happen too. But that's not what this is supposed to be doing. You have to be brutally honest in your assessment. And I often like to think, well, what's the other side actually? What's their take on this? And when you see 80-20, you saw it in a real life example. And I think Mike would agree, and the others on the team would probably agree that that was a realistic, good assessment of what might happen in a courtroom, right? But you have to be really careful with those. We talked about ADR. I'm going to stop because I think maybe it would be more useful to see whether you have either questions of us or you want to go out and grab a coffee and stop. So over to you.
Nothing in the room.
Nothing. So
Anything from any of our online folks? Looking at. No?
we have sorry, there is a couple of questions in the crowd. The gentleman here. I would have thought that if you're going through this kind of an exercise and you've come up with a reasonable assessment based on the information that you have, I don't think that you can ever be faulted for not having met the applicable standard of care. I would turn this on its head, and I would suggest that if you don't go through one of these analyses and you haven't thought of the issues, at least in some way, maybe not in a chart, but in some way, I think you're more likely to have failed to meet the standard of care of a competent lawyer. Mind you, if the chart reflects a radical mistake, then, and assuming for a moment that it's producible, remember I talked about privilege issues. So if it's subject to solicitor-client privilege, I would have thought it's never going to be producible unless the client waives the privilege when they're suing you, which is an uncomfortable thought, but it could happen. So I think the answer to your question is my gut tells me doing it is probably still a better thing than not doing it at all.
And a consideration that goes into that, I think, is depending on the level of involvement your client has, if you're going through this with them and there's a disagreement between your analysis and theirs, this helps foster debate and might identify issues like that before it comes to the point where somebody's getting sued.
Yes. There was another question at the back, please.
Done any analysis on after the fact, so after you've got a judgment or anything like that, to see actually how accurate the assessment is?
No, because once you have your judgment, you're either really happy or you're really unhappy, and so you're either appealing or you're responding to an appeal or you're just putting the file away. So I've actually never, actually that's not quite right, sorry. We have done it. We have done a brief where the client lost a jury trial in the U.S. and had treble damages award against them, and there were a whole bunch of questions on appeal, and they had lost. I think the principal jury amount was $19 million and change, and with treble damages, obviously it trebled that, and there was an offer out there to settle for $35 million. The plaintiff offered to settle for $35 million, and we were retained to do the risk analysis to see whether the settlement offer of $35 million was something that should be considered, yay or nay, and it was for the C-suite. And they actually decided at the end of the day, they did settle it for less than $35 million, in part based on the analysis. So it wasn't to look at whether the trial judge, I guess in part, it looked at whether the trial judge's instructions to the jury were subject to criticism by the Court of Appeal in that American jurisdiction. So I guess we did what you're asking, but we haven't, sort of as a matter of course, taken all our files that have gone to trial and then done a retro just to see, was the trial judge close to what our analysis suggested, which I think is more what your question was. It's a good question. I don't even know if there's materials out there. There's some literature at the end of the slide deck. I know George Adams has written a lot about this stuff, and others in the U.S. as well. So there may be something out there. Okay,
Right on
so well, I hope that was somewhat useful, and really want to thank you for coming this morning and spending some time with us, and on the web as well. Thank you.
Thanks.